Hey, good afternoon, Judge. How are you?
I'm good. How are you?
Good. Good to see you.
Yes, haven't seen you in a while. Good afternoon. This must be the Saturday crew, huh?
Yeah. Well, on this particular day, we all take turns.
Yes, I understand.
Good afternoon, Judge. This is Katrina.
Yes.
Um,
Haven't had you in a while either.
oh no, you haven't. Nobody have. I've been missing in action.
I was just say happy New Year to everybody.
Well, thank you.
Is it too late to say that? I guess this is about the end of the month.
Beginning of the year.
Yes.
Our reset date for the SAP is going to be February the 9th.
Okay.
Yeah, it's not too early to say Happy New Year.
So I guess y'all ready to go whenever everybody's.
Okay, I see a message in the chat.
Yes, Your Honor. Just that particular case, if we could have a breakout room for the court and our office in the state.
Okay. All right, got that. All right, I'll go ahead and give my opening and we'll get started. Good afternoon, everyone. My name is Judge Regina Mincing, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will generally be the defendant's initial appearance before a state court judge. So we're able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made at this juncture. Again, that reset date is February the 9th. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Govern yourselves accordingly. I want to also remind the defendants that you have certain constitutional rights. The first being that you have a right to representation at this juncture, at this hearing. And most of you, if not all of you, know who your attorneys are. So listen to them. You also have a constitutional right to remain silent. Anything that you state about the facts, the circumstances, and the occurrences of your case can and will be held against you. Solicitors are here. So again, listen to your attorneys and govern yourselves accordingly. All right, who do we have first, Deputy?
We can start in courtroom 2, position 10, Mr. Pass.
Okay. All right, this is case number 23 CR 0000554G. Rashawn Pass. You're charged with 1 count of stalking, 2nd count of criminal trespass. The offense date is May 30th, 2022. Pre-trial?
He has 1 prior arrest from 2018 for theft by shoplifting. In that case he completed pretrial diversion and it was dismissed.
Okay.
Good afternoon, Judge. This is my case.
Okay.
As you stated, Judge, this is an incident from last year in May 30th. It occurred at the location of 14381 Club Circle in Milton. And that's where the criminal trespass took place. The officers responded to that location, Judge, because the owner of the property had some damage to his fence. It appeared that it was damaged when somebody jumped over the fence. That's what it appeared like. There was a backpack left on scene, and when they went through the backpack, it had the defendant's driver's license information in that backpack. So that's how they were able to identify his responsibility in that portion of this offense. On that same day, Judge, the officers responded to a 14560 location across the street adjacent to the criminal trespass. That is where the defendant was a possible suspect in a stalking case against the victim, Carly Winters. She and the defendant used to date, and they were not dating at this time. She reported that she suspected that the defendant was following her. He did appear on her front door at 12:30 in the morning, and he was banging on the door and trying to enter her property at that time. She also told the police that he came back, and she believed that she saw him in the backyard in the area of 3 a.m. on that same day. There was some previous incident between the two of them where they were having dinner or something at the Lost Dog Tavern in Buckhead, and he was so rowdy and so angry with her that she had to be removed from the property. So she was concerned about his behavior. Judge, pretrial told you that he doesn't have much criminal history. Correctly, I reviewed his criminal history, and it does look like I only see the theft by shoplifting from 2018. But we are concerned, Judge, that he does present a risk of danger and intimidation to the victim in this case, Carly Winters. He came to her house twice in one day in the middle of the night, banging on her door, and then he was on her property in her backyard, which is extremely concerning. And when it looks like what he did to the other person's property is he damaged their actual property, and that victim is Patel Deep. So we are concerned that he will return to that property, and we are concerned that he would cause more property damage. So based on that, Judge, and based on the fact that this is a stalking charge, we're going to recommend for the criminal trespass a $2,000 surety bond for the criminal trespass, a $3,000 surety bond for the stalking offense. He is to have no further contact with the victims in this incident. And the first one is Carly Winters. That's common spelling, Carly Winters. And the victim of the criminal trespass, Patel Deep, Patel, last name Deep, Deep. And that he would have to stay away from the incident location in Milton. Nothing further from the state.
All right. So there would only be one address for the stay away
I'm sorry, it should be
recommendation?
a second address should be added to that too, Judge. Let me just make sure I have that correct, because it's it was Mr. Patel's property and then Ms. Winter's property. And I just want to make sure I have the correct address for her. You give me one moment. I have it right here. Pulling up. Okay, so the first address is 14381 Club Circle in Milton. The second address would be 14560 Creek Club Drive in Milton. And I believe that's the street adjacent is how it's described in the warrants.
All right. Is this Ms. Bronstein, PD Bronstein?
Yes, Your Honor. I'll be representing Mr. Pass today, and he does qualify for the Public Defender's Office. He is 22 years old, as the state said. He does not have any prior convictions. And as the state pointed out, this case is 8 months old, and there have been no further instances whatsoever, no contacts with the law. The complaining witnesses in this case have not made any additional complaints regarding Mr. Pass. So I truly do not understand their implication that now 8 months later, he's suddenly a danger to them. He is a junior at Georgia State. He is currently studying business. He is from the Metro Atlanta area. His entire family is here. As I stated, this is 8 months since. My understanding that this case took place when he and the complaining witness in this case had just broken up. My understanding is that they are still friendly, but they are no longer together. He has no issues completely staying away from her based on his lack of criminal history, the length of time since the case, the fact that there have been no further instances since, and the fact that he is ties to the community and is a student, we are asking the court to consider a signature bond in this case.
Okay. All right, I'm going to order a $5,000 signature bond through pretrial per judge. That's $3,000 on the stalking, $2,000 on the criminal trespass. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the victims, Patel Deep and Carly Winters. And I'm going to order a stay away from 14381 Club Circle and 14560 Creek Club Drive. And I think that will be it for my ruling. Anything else, counsel?
Nothing further from the state, Judge.
Nor from
Okay.
the defense, Your Honor.
Thank you.
This is Katrina. That's a $5,000 total bond
Will he
Yes.
seek a co-signer?
through pretrial.
He's 22. I don't think pretrial, he doesn't need a cosigner, does he, pretrial? He's 22.
No,
Okay.
All right, thank you.
Thank you.
Right, so it's the $5,000 signature bond through pretrial.
Yes, $5,000 signature bond through pretrial, $3,000 on the stalking, $2,000 on the criminal trespass.
Thank you.
Mhm.
We'll go to position 6 at the ACDC, South Annex.
Okay. This is case number 23 CR 0000551C. Stephanie Herrera de la Rosa, charged with 1 count of battery family violence and a second count of battery family violence, 2 counts, both with the offense date January 27th, 2023. Pretrial.
first arrest.
Okay. ASG Gardner.
I apologize. My computer is wanting to flash up things in front of me when I click on unmute. Your Honor, this case or this incident occurred on, early yesterday morning, January 27th, between 5:40, 7:09 a.m. It occurred at 2308 Sandalwood Drive in Sandy Springs, where the defendant lives with her husband, Juan Roman. When Officer Smith arrived in response to a domestic violence call, he found Mr. Roman standing at the front door. He didn't have a shirt on, and he could see a large bloody bite wound on his chest. Mr. Roman did relate to him that he and the defendant, who is he stated was his wife, were arguing about her coming home late from work. He would not at that time, however, let either of the officers that were there inside of the home to speak with the defendant. Unfortunately, Officer Smith was called back to the scene shortly thereafter. He was able to speak with both the defendant and the victim at that time, and they both confirmed the previous facts that Mr. Roman had stated. And apparently after he left, they continued arguing. This argument traveled throughout the house, upstairs and downstairs. At one point, Mr. Roman threw a pillow at the defendant, and she responded by charging at him, and he pushed her away several times. He stated that she punched him multiple times, and the officer did later see a laceration under his lip that he said was a result of that punch. She followed him downstairs. Mr. Roman reported that she attempted to grab a knife from the kitchen. At that point, he directed their roommate, Mr. Jamel Thomas, to call the police, and that's why they were called back to the scene. After the police were called, the defendant went upstairs to change one of their children's diapers, Mr. Roman followed her. This led to yet more arguing and fighting. And according to Mr. Roman, the defendant tried to punch him again. That is when he grabbed her to stop her advancing on him, and she bit his chest, which was left the mark that the officer saw at his first visit to the house. Now, the defendant did tell the officer that she attacked Mr. Roman in self-defense, but she was unable to show him any injuries or, upon questioning, specify any details of any specific acts by Mr. Roman against her. Both parties did admit to a history of domestic violence between them and that they were in the process of separating when this happened. The state recommends a bond of a $2,500 surety bond on each of the 2 counts of battery family violence, that the defendant stay away from the home at 2308 Sandalwood Drive in Sandy Springs, that she have no contact with Juan Roman, and that she not have any drugs, alcohol, or weapons.
All right.
Yeah, that is my case.
Bartels. Okay, Bartels.
Your Honor, my client is 24 years old. As pretrial has indicated, she has no criminal.
Can't
I'm
hear you.
advised.
Oh.
I said, I'm told that this is her first lifetime arrest. I'm advised that she works full-time at the North River Tavern restaurant. That's very close to where she lives, the Sandalwood Drive address. I can get that to that in a moment, but she does work full-time. She has 3 kids, Your Honor. It appears she and the alleged victim, well, my understanding is that they're not legally married, so that the one child they have together, Ms. Herrera de la Rosa, is the one who has custody of that child, a 9-month-old girl, and then she has 2 other children that she's taking care of. So she is a working mother. She does work full-time. I understand this is not a trial or an evidentiary hearing, but it appears from the warrant, it's not disputed that the alleged victim, Mr. Roman, is the one who started the argument because he was upset about her staying late to do her job. It also appears from the warrant that he threw a pillow at her, which hit one of her children. And again, if this were a trial, our position would be that she is a mother who was defending herself and her child. So given all of that, we would ask for a signature bond. I believe that would be appropriate in this case. Regarding a no further contact versus a no further violent contact order, I have not been able to reach the alleged victim, Mr. Roman. I don't know if the state has been able to. My client tells me that they have apologized and are hoping that they can work their relationship out. So my client was hoping for a no further violent contact order, also because this address at Sandalwood Drive, that's very close to her job. She can walk to work. But if the court were inclined to have a no further contact order, my understanding is that Mr. Roman would be living with his sister's home in Kennesaw. So if the court is inclined to do a no further contact order, we would ask that Ms. Herrera de la Rosa be able to stay at this address on the condition that Mr. Roman is not there. And again, we would ask for a signature.
Okay. All right, I'm going to order the $5,000 signature bond through pretrial per judge. That is $2,500 on each of the battery charges for a total of $5,000. No drugs, alcohol, or weapons while on bond. I'm going to order no further contact at the moment with Mr. Roman. But as far as a stay away, since I understand she has children, and I'm not for sure whose name is on that lease, if it's both of them or not, but I'm not going to order a stay away, but put the condition that the defendant can reside at the location, the 2308 Sandalwood Drive, as long as Mr. Roman does not reside there. So
Thank you, Judge.
when she gets out, she needs to have a police escort to go back. What I usually do so that they can determine, the police can, law enforcement determine that Mr. Roman does not reside there and that she and the children can reside there safely as well. Hasn't been that much time. Hopefully there's going to be some cooling down.
Mhm.
But if the defendant goes back to that residence and Mr. Roman is still residing there, then she cannot reside there.
All right, thank you, Your Honor.
All right,
Thank you, Your Honor.
no problem.
Position 11, Ms. Presley.
This is 23 CR 0000555F. Brooklyn Presley, charged with 1 count of battery and a 2nd count of disorderly conduct. The offense date, January 27, 2023, pretrial.
First arrest.
Okay. All right, ASG Harmon.
Yes, Judge. This is an incident that, as you know, took place on 127, and the location is Clark Atlanta University at 15 James P. Brawley Drive. The defendant and the victim in this case, her name is Faith Lloyd, for the record. They are roommates at the college, and they've known each other since last semester. The victim tells us that the defendant has always had a problem with her and been antagonizing her. And I guess it erupted into this incident in which they got into a fight, essentially. They were fighting, and the victim, Ms. Lloyd, sustained what the officer described as severe damage to her right eye with swelling. The victim also told our office that during the incident, she tried to talk to the defendant to try to make peace and settle their differences. The defendant was really not trying to hear that. She said that her injuries were a bruised spine, the right eye bruised and swollen shut. She has hair loss and scratches on her body. She did have to be treated at Grady's Children's Hospital on the same day of the incident. And we do expect to get her medical records, and we will be reviewing this case to see if it rises to the level of an aggravated assault. And our understanding is that she does intend to file for a TPO, as she is fearful for her safety against this defendant. This was a hellacious act of violence. It was just an attack, a sustained attack on the victim. And even though she has no history, our recommendation, because of the level of violence displayed and the injuries to the victim, is a $5,000 surety bond. She should have no further contact with the victim, a 1-day anger awareness class, and she needs to stay away from the incident location. And I understand, Judge, that this is a college and dorms are assigned, but she needs to be relocated or stay somewhere else until the college can relocate her for the safety of Ms. Lloyd in this case. That's the state's recommendation.
All right. Ms. P.B. Bronstein.
Yes, Your Honor. Ms. Presley is 20 years old. She is a junior at Clark Atlanta University. This is her junior year. Actually, she skipped a year due to having so many college credits when she was in high school. She's a very high achiever. When I spoke to her, my understanding from her is that yes, she and her roommate had differences. And in this situation, her roommate got very combative, got in her face, said multiple times that she put Ms. Presley's head through the wall, shoved her, grabbed her arm, and pushed her before Ms. Presley fought back. So this is our position as that this is not an attack, this was someone defending herself. Additionally, as that she has already spoken to the school, and it's her understanding that she'd be moved to a different floor, so that she would not need to speak to the roommate anymore. So we would ask for no contact with the former roommate, but not that she be prohibited from staying at a different floor. We are asking, due to the lack of criminal history, that the court consider a signature bond in this case, otherwise a bond not to exceed $1,000.
And Your Honor, just to, we would be concerned if she's still in the same dorm location that they could run into each other practically on a daily basis, because that's where they stay. So we would ask that you would make her contact that she would either have to move to another dorm or another location so that they can, so that the victim can remain safe in this case.
Okay.
And Ms. Presley is worried about her safety from the complaining witness as well.
So it'd probably be best that they're not in the same dorm.
It's kind of hard, I guess, with college and them having dorm space or moving her to a different dorm. I don't know if I can order that or should order that, because Clark Atlanta may not be able to accommodate that. I know that college, as well as some of the others, don't have enough dorm space usually. The students are in hotels and apartments off campus. So I want to make sure that I don't give any conflicting bond conditions. But I will grant the signature bond. And I'm going to grant that through pretrial in the amount of $5,000, $2,500 for, I'm sorry, $3,000 on the battery and $2,000 on the disorderly conduct, for a total of $5,000.
Okay.
I'm going to order no drugs, alcohol, or weapons. And I'm going to order no further contact with the victim, Faith Lloyd. And so, since there's no further contact, obviously, the defendant will not go back to be roommates. And so hopefully the college can accommodate that request, or she'll have to move off campus into an apartment. But I'm not going to, and I'm thinking of this dude, stay away from the dorm building, although I might need to. But I don't know what else goes on in that building, or if there's, it's just a dorm. And I don't know if the attorneys have any feelings about that. She's got to definitely stay away from the victim, Faith Lloyd. But if she has any other business in that dorm or any other friends, I don't know if I'm going to want her to go there and possibly run into Miss Lloyd, or not at all. What's your feelings, counsel?
Can I ask, Ms. Presley, do you know if they were planning to move you to a different dorm altogether, or just a different floor?
It was just a different floor. I was going to the second floor. I originally stayed on the third floor.
I could barely hear. Let me see if I turn up my volume a little bit.
She said that they're planning to move her from you said from the second floor to the third floor?
No, from the third to the second.
Would there be an issue with you staying away from the third floor entirely?
No, I shouldn't need to go to the third floor at all.
Could we just have her stay away from that floor, and that if she sees the complaining witness, that they have no contact and that she just leaves?
And Judge, the state's position is the same. We would ask that you would order her to stay away from that dorm building, because there's common areas that all the students have to share, the elevators, stairwells. She can run into Miss Lloyd at any time. She could stay off the third floor, but she would essentially have to just stay in her room and promise to never run into her, which I think is impractical. I think it's just more practical to say that she can't be at that dorm. So she would have a lesser of a chance to encounter Miss Lloyd. So that's our position, Judge.
All right. Ask Ms. Presley, how many floors are in this dorm?
There are 4 floors.
Oh, it's only 4. So it's a small dorm. It's not a huge dorm. There's only 4 floors.
And again, if the judge, if the defendant and the victim are having, it was a level of violence displayed here. Counsel has said there is concern for the safety of her client as well. I think it's just best for all parties involved that these women be kept apart as much as humanly possible.
All right. And of course, our victim is our concern that she be safe in her dorm room. I don't know, especially this is not a 10-story dorm building, should I say. So it's not a huge one. And I am concerned that it's going to be hard not to cross paths on the elevator going in and out and things of that nature. There hasn't really been that much of a cooling down period, and there are allegations of some serious injuries, which do concern me. So what I'm going to do, counsel and Ms. Presley, is to order you to stay away from that dorm. And obviously, when you get out, you can share this bond order and conditions with the officials at the college to see if they can assist you in finding some other temporary housing or staying off campus until this case is over, so that you don't violate the bond conditions as well by running into Ms. Lloyd. I'm sure you can run into her on campus. Do you all have the same majors? You don't? Okay. So you don't have any classes with her? Okay. But I'm concerned about them running into each other in the dorm. Ms. Bronstein, go ahead.
Oh, I was just wondering if she could get a one-time with a law enforcement escort just to get her stuff once she has her housing situated.
Okay, right. And what I'll do is I will order Ms. Presley that you will have a one-time law enforcement escort to go back to that building. So once you are released from the jail on the signature bond, you're not to immediately go back to that building until you have arranged to have law enforcement escort you. I'm going to put law enforcement or campus security, because I do know obviously that they have their own security force there, and I'm okay if it is them as opposed to APD or Clark Atlanta.
Judge, I'm sorry to
Yeah.
cut you off. Would she need a cosigner? She's 20.
I thought it was just 18. Tell me, pretrial
That's
cosigner.
correct. It's just 18, but if they need a cosigner, I'll make that announcement.
Okay, yeah, she does not. And thank you, Deputy. 18 is that magic number. I know we've had some 17-year-olds in the past who have needed them. 20, she does not. And I'm assuming, is Miss Presley from Georgia?
She is not originally from Georgia.
Okay, but she's been here for college.
Yes, she's been here for college.
Okay, all right. Well, that's a pretrial bond. But I'm also going to order the one-day anger awareness course through pretrial. And I said no drugs, alcohol, or weapons while on bond. And I guess that's it. That one-time escort from law enforcement or campus security to get your things from the dorm, Ms. Presley, and then stay away from that dorm. And again, as I've stated, if you see Ms. Lloyd coming your way or anywhere in your purview, you need to go the other way so that you don't violate your conditions of your bond to stay away from her. No discussing of her or this case on social media, no emails, no third parties contacting her on your behalf. I'm going to make sure that you stay clearly away and there's no outside or social media contact with her either. All right. All right. Good luck to you.
Position 12, Mr. Russell.
All right. This is 23 CR 0000538B. Jaheem Russell, you're charged with 1 count of battery family violence and a 2nd count of simple battery. Offense date January 26, 2023.
Your Honor, I have a question before we start. He was on the SEA calendar yesterday. I don't know if the state added a charge or amended it. I see a bond order for 1 charge in Odyssey, but when I look at his booking screen, it shows no bond for everything. So I don't really understand what's happening. So I just
I
asked.
can explain to you. I can explain what's going on.
Thank you.
Okay.
Apparently, Judge, he was on the SEA calendar yesterday and they addressed it only 1 charge. The state didn't have the other charge in the system. They amended the simple battery charge to a battery charge. So only thing that needs to be addressed is the battery charge. He already has a bond on the simple battery charge from Judge Williams of a $500 cash bond. So only charge that need to be addressed is number 1. The jail didn't post the bond until they hear from this other charge. That's the reason why it's not showing on his booking screen at this time.
Oh, okay. Right. So that's it. That simple
So all we
battery.
really do is need to amend the bond, amend the original order to address the battery charge.
The battery. Okay. All right. And there's a $500 cash bond on the simple.
Already on the simple battery, that's correct.
Gotcha. Thank you for that. So you were there yesterday as well.
I wasn't
Good.
there, but I get my information correct with my calendar.
All right. Well, thank you. I appreciate that. All right. Pretrial.
Showing 9 cycles.
I'm sorry.
I'm showing 9 cycles.
Okay.
He appears to have an open case out of DeKalb County from March of 2022 for possession of a pistol or revolver by person under 18 years of age. He has a burglary conviction from 2020 out of Illinois.
I can barely hear you.
Can you hear me?
A little bit better. Let's see now.
Can you hear me?
That's a lot better. Thank you.
A burglary conviction out of Illinois from 2020. And he may have a second open case out of Illinois from September of 2022 for vehicle theft. There's no disposition listed and nothing further.
All right. Thank you. All right. ASG Harmon.
Yes, Judge. This is a case, a domestic violence case, Judge, and this happened at 1073 Hollywood Road Northwest in Atlanta, and it concerns Miss Armani Bright, who is the parent of the same child with the defendant, Jaheem Russell. The defendant was allegedly shoving Miss Bright back and forth while she was trying to make a 911 call, and during the shoving match that he had with her, she did sustain bruising to her face and her chest area. We do believe, Judge, that he is a danger to her. He was essentially preventing her from getting help and calling 911. She was 1 month postpartum at the time. And of great concern is the open gun charge from in DeKalb County. The victim did reach out to our office, we did reach out to the victim, and she advised that she is in fear of the defendant and she does not want any contact with him whatsoever. She said this is not the first time that this happens. There are some of the defendant's belongings at her residence that he needs to retrieve. And so she's in agreement with a one-time law enforcement escort to retrieve those things, but she's scared of him. And so, Judge, we think in this, on this battery family violence charge, we're going to request a $500 cash bond to stay away from the incident location of 1073 Hollywood Road, Northwest in Atlanta, to have no further contact with Miss Armani Bright, That's ARMONIE. Last name is Bright, BRIGHT. That there will be a third-party transfer of the child. The one-time law enforcement escort, that he would have no further contact with her. And that he would have no alcohol, drugs, or weapons while bond is pending in this case. Nothing further from the state judge.
All right, PD Bronstein.
Thank you, Your Honor. Mr. Russell is 19 years old. He is actually still in school. He's in 12th grade alternative school. He told me Southern House Academy, and that he attends virtually. He informed me that there is nothing that he can pay for bond, that he has the money, but it's at her house, and he cannot access it at this time. We're asking that the court take that into consideration when determining a bond amount for this case. And we're asking that there not be a cash bond on this charge.
And he resides with his mother, father.
So he was down here with her. However, with the stay away, he won't be around her anymore and would go back to live with his family.
So Armani Bright is his child's mother.
Yes, they have a 2-month-old baby.
And they were residing together,
Yes, ma'am.
but not with any family members, just in their own apartment or her own apartment.
That is my understanding. Or at least that his family wasn't there. It's not like she was staying with him and his family.
Okay. Now he's 19, but he's still in high school. So pretrial.
Yes.
So he's still considered a minor. I guess he hasn't graduated from high school, although he's 19. If he were to get a signature bond, he would need a cosigner, or still not.
No, unless you order him to have a cosigner.
Okay. Well, I am concerned with the allegations and his history, as well as his open gun case. I'm going to order on this other battery charge a $10,000 surety bond. And it'll be a split bond, I guess, Miss Lewis. $10,000 surety on the battery and $500 cash on the simple battery. Is that my understanding?
Yes, ma'am.
And then I'm going to order a stay away from 1073 Hollywood Road Northwest. Don't know if that was an apartment or not.
Judge, I would check 1 second.
In the previous order, Judge William had no further contact with the victim, stay away from the location, a one-time return with law enforcement to retrieve personal item with no drugs and alcohol, no weapon. That was in the first
Right.
order.
Those sound exactly like what my conditions were going to be as well. So no further contact with Armani Bright, stay away from the incident location, one-time law enforcement escort to return to retrieve his personal items, no drugs, alcohol, or weapons while on bond. And there was no order for third-party transfer, was it?
No,
I
ma'am.
think I'm not gonna do that. Right. Yeah, this is just a 2-month-old baby, so I doubt, given the circumstances, that she would be comfortable if she's afraid of him with sending her child. So I'm not going to order that either.
Okay.
I was almost going to put the 2-month-old as a victim in the case for a stay away. But I'll leave it where it is. think that's it. Anything else, council?
No, Your Honor.
And
All right.
yes, it was an apartment, to answer.
Oh, it was. Do we have the apartment number at all?
Yes, Judge, it's apartment, apartment 3.
Apartment 3. Okay. All right. Oh, I'm looking at my chat. Hold on a second. So Judge Williams yesterday, okay, did not. Okay. I'm just catching up reading. All right. Thank you. All right. That should conclude this case.
Thank you.
Thank you, Your Honor.
Oh, I'm sorry. I don't know. Mr. Russell, your attorney will instruct you on what to do if you have a question about the bond condition.
No, I got another question. I was trying to see something. I was trying to see how am I charged with a simple battery?
Mr. Russell, we've already discussed this. The state did add there are 2 charges stemming from the same event that they're alleging 2 different things. Going forward, your next court date, if you don't get out of jail, it's going to be an SAP calendar, and that attorney will have more information. I'll be able to explain that to you more fully.
And then another thing, I was trying to see, instead of a surety bond, could I get like a cash bond, because I can't bond out here because I ain't got no other family, and they say I need a co-signer, somebody that's been working for over a year with with check stubs and utility bills and stuff, and I can't find nobody with that information in order for me to bond out. That's why I'm asking for a cash bond. And also, it's like she before she even stepped in the house,
Mr. Russell, let's not talk about the case.
No, my only question again is, who does Mr. Russell live with, or where his parents or family? That would have been my only question in that.
It's my understanding that his family is out of state.
Okay. Well, you may have to come back for a bond modification. This just happened on the 26th, 2 days ago. And I want to make sure there's been the ample cooling down period. And I think you stated that he's going virtually to an alternative school.
Yes.
Okay. So right now, that's what I feel comfortable with, to make sure that we have the ample cooling down period, Mr. Russell. And then you can speak to your attorney if she needs to request bond modification if you're unable to make bond. But we haven't said that you need a co-signer because you don't have a signature bond, but I don't know about the bonding company's requirements. And I'm not privy to that information.
All right, position 14, Mr. Solomon.
Okay. This is 23 CR 0000557H. Antoine Solomon, the charge of 1 count of willful obstruction of a law enforcement officer and 2nd count of theft by taking, both with the offense date of January 27, 2023. Pretrial?
Yes, 12 cycles. A 2018 conviction for battery, family violence, false imprisonment, aggravated assault, unlawful conduct during 911 calls. That was out of Douglas County. He has 1 FTA from 2018. A probation violation from 2018. A theft by shoplifting conviction from 2019. A 2nd probation violation from 2019. A 3rd probation violation from 2019. A 4th probation violation from 2020. Nothing further.
All right, thank you. ASG Harmon.
Yes, Judge. This is an incident that took place at 1180 Virginia Avenue in Hapeville at the racetrack gas station. Officers did respond to that location because they received a call about the defendant indicating that he would not leave the premises. When they made contact with the defendant, he told them that he was waiting on his Uber ride. They made contact with the supposed Uber driver, and she denied being his Uber driver. He wasn't waiting for an Uber ride. The clerk came out of the store and made contact with the police and told the police that the defendant took some green in color lottery tickets from the store. They were trying to detain him, and when they were putting his hands behind his back, they saw green lottery tickets matching the description that the clerk gave in his front pocket. He initially told the officers that he took the tickets from the garbage. He later recanted and said that the clerk gave him the lottery tickets, said he could have them. The value of the lottery tickets were $61. When the officers were asking him to identify himself, he refused to give them proper identification. Judge, we're clearly concerned with the number of FTAs, the recency of the FTAs. We're clearly concerned with a similar offense with a theft by shoplifting from 2019. We're also concerned with the fact that he has multiple probation violations. And Judge, when I was reviewing his criminal history, it appears that he is a multi-state offender. He has 52 cycles in Florida. And in Florida, he had a 2014 conviction for a battery on a law enforcement officer as well. So we think, based on this criminal history, we do think that there is a high risk of reoffense. We do think that he does present a flight risk because of the recent FTAs. And there are similar offenses in his criminal history that concern the state. In light of that, Judge, our recommendation on the willful obstruction is a $1,000 surety bond. On the theft by taking, a $1,000 surety bond. We would ask that you will order him to stay away from that location of 1180 Virginia Avenue, the racetrack, and that he is to have no alcohol, drugs, or weapons. Nothing further from the state.
All right, PD Bronstein.
Thank you, Your Honor. Mr. Solomon is 43 years old. His whole family is in the Atlanta area. He has children 12, 19, 20, 27 years old. He also has a 1-year-old grandson. He finished high school. He was out of work. He had been out of work at this time. However, he did get a job with Amazon, Amazon warehouse starting on Sunday. He did the interview. He passed all the tests. He passed the drug test. He got the uniform and he's all set to start on Sunday. So he is asking that the court let him out so that he can start his job and do a bond low enough that he would be able to afford. Again, this is not a violent offense. He wanted me to request a signature bond from the court. If the court's not inclined to do that, we'd be asking for a total bond not greater than 1,000 surety.
All right, I'm going to order the $2,000 surety bond, 1,000 on each of the charges. I'm going to order stay away from 1180 Virginia Avenue, which is the racetrack in Hateville. I'm going to order no drugs, alcohol, or weapons while on bond. And I believe that's it. Anything else, counsel?
Nothing further from the state.
Nor from
All
the
right.
defense.
All right, that'll conclude this case.
Position 9, Mr. Oliver. Call you.
Oh, did the state recently add the driving while license suspended charge? I didn't see that on the booking screen.
No, it was originally charged.
We have the 3 charges.
Yes, Your Honor.
This is case number 23 CR 0000558J. And the case is Antravius Oliver. We charge it one count of speeding, second count of reckless driving, third count of driving while license suspended or revoked, all with the offense date of January the 27th, 2023, pretrial.
Showing 22 cycles. Last arrest, March 7th of 2022 for a probation violation. He appears to be on probation out of Fulton County for possession of a firearm by a convicted felon. Case number 17 SC 152681. Disposition January of 2018. 3 years confinement, 3 years probation. Showing an FTA from 2018. A total of 3 probation violations. Another FTA from 2010, a felony theft by shoplifting conviction 2010, a possession of a Schedule I controlled substance conviction 2010, possession of cocaine with intent to distribute conviction from 2010. And I'm showing 1 arrest out of Louisiana from 2017 for theft. There's no disposition listed. And nothing further.
All right. ASG Gardner.
Thank you, Your Honor. On January 27th at about 11:27 p.m., Officer Noble observed the defendant driving a Kia Optimal at a high rate of speed. And this was at Georgia 400 northbound at Windward Parkway in Alpharetta. Officer Noble clocked him at going 112 miles per hour in a 65 mile per hour zone. This, as I said, was around 11:30, and there were multiple cars out on the road at that time. After Officer Noble stopped him, he did determine that the defendant's license had been suspended in February of 2016 for an FTA. I think it should be noted that we found that in case number 10 SC 93062, and this is a 2010 case, but the defendant was convicted for theft by receiving an auto and reckless driving and obstruction. We count 1, 2, 3, 4 FTAs, possibly 3 FTAs, one of which has resulted in one of the charges that he's charged with today because he failed to appear at that time. He's previous speeding of 80 in a 55. We're asking that he be given a surety bond of $1,000 on the first count of speeding at 112 and a 65, $2,000 surety bond on the reckless driving, $1,000 surety bond on the driving while license suspended, no drugs, alcohol, or weapons, and no driving.
All right. PD Bronstein.
Thank you, Your Honor. Mr. Oliver is 31 years old. His whole family is in Atlanta. He did graduate from high school. He does work. He does sanitation at a chicken plant. For work, it's a carpool, and it's over an hour each way. He's very dedicated to his job and getting to work. Also, I think the state had previously asked, we are representing him for the purposes of bond only, unless he's unable to get out of custody, of course, and his work situation changes. He's one of those who he doesn't technically qualify, but still doesn't make much money, does not have much money to be able to bond out. He is asking, he wanted me to request a signature bond from the court, or a total surety bond not to exceed $1,000.
All right. I'm going to order a $2,500 surety bond. That'll be $1,000 on the speeding, 1,000 on the reckless driving, and 500 on the license suspension, for a total of 2,500 surety. And I'm going to order no drugs, alcohol, or weapons while on bond. And no driving while on bond unless he has a valid driver's license, but I guess he won't. And also no drugs, alcohol, or weapons. Did I say that already?
Yes.
I guess the key here would be no driving unless he has a valid license.
That's correct, Judge.
Okay. All right, that should do it. Anything else, counsel?
Nothing for the
None
state.
from the fence.
That was position 1, Mr. Butler.
All right, this is 23 CR 0000546B. Armand Butler. You're charged with 1 count of battery family violence and the 2nd count of simple battery family violence. January 22nd, 2023 is the offense date. Pre-trial.
On 2 prior arrests. They are both for simple battery family violence. The last arrest was January 9th of this year in Union City. And then the first arrest was July 25th of 2021 with South Fulton. The first case number I have is 21 CR 003-797B. I do not have a case number for the most recent arrest.
Okay.
Nothing further.
All right. ASG Gardner.
Thank you, Your Honor. This offense occurred on January 22nd. It occurred at 6295 Oakley Road, apartment 206. And this is in Union City. And according to the warrant, the defendant pushed Sherry Harris to the ground and then punched her face, causing her lip to bleed. They are in a relationship. According to the warrant, they also have 2 kids together. Although he has no previous convictions, the state is very concerned that he has this open case. And in that case, he is accused of placing his hands around the neck of Zaisha Thomas, who he also lived with in the same household with at that time. He was arrested on July 25th of 2021 for that. And then it's also very concerning that he was arrested just a few weeks ago in Union City for the same offense. We don't have the details on that. Presumably it's still in municipal court at this time. But we are, based on this activity, concerned for the safety of the victim. We have not been able to reach her. We do not have good contact for her at this time. And we're waiting on the actual report. But we're concerned for her safety and also his risk of reoffending. So we are asking for a $2,500 surety bond on the first counts of battery family violence, a $1,500 surety bond on the second count of simple battery family violence. Stay away from the entire apartment complex at 6295 Oakley Road. No contact with the victim, Sherry Harris, and that's SHERRIE Harris, HARRIS. And of course, no alcohol, drugs, or weapons while on bond. Nothing further from the state.
All right. Mr. Bartels?
Yes, thank you, Your Honor. I have talked with Mr. Butler. I also tried to get in touch with Ms. Harris. I was not able to get any contact information from her. Mr. Butler, Judge, I'm told he is employed full-time. He works at Taco Bell. He does have his mother, and he has several cousins that live in the metro Atlanta area. So he does have ties to the community. He does dispute the allegations in the warrant. What I'm told is that Ms. Harris, that there was another person over at Ms. Harris's home, and this other person and her were threatening him. But again, I understand that there's a time and a place to argue that, but he does dispute the allegations. I'm also advised that he does not live at this location, so there would not be a problem with a no further contact order. I'm advised that he lives with his mother. And given all that, he is wanting to ask for a signature bond so that he can get back to his job. And again, there's no issue with the no further contact order. If the court is not inclined to grant that, we would ask for $1,000 bond on the battery charge and a $500 bond on the simple battery charge.
Okay. I'm going to grant the $5,000 signature bond through pretrial, $2,500 on each charges per judge, $2,500 on each. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order stay away from, is it 6295 Oakley Drive?
Yes, ma'am.
Yes, that's correct.
And no further contact with the victim, Ms. Harris.
Okay, thank you, Judge. Mr. Butler, you don't have any property at that location, do you?
Sir.
Do you have any property at this location?
No, sir.
No, okay, all right. Yeah, thank you, Judge. So there's
All right,
no
that'd
issue
be it.
with that.
Right, good, thank you.
Position 2, Mr. Collier.
This is case number 23 CR 0000547J, John Collier, charged with 1 count of criminal trespass, 2 counts of willful obstruction of a law enforcement officer, and a 4th count of disorderly conduct. The offense date is January 27, 2023. Pretrial.
4 cycles. He has a criminal trespass conviction from August of 2022 out of Cobb County. A 2nd criminal trespass conviction also from August of 2022 out of Cobb County. Theft by shoplifting conviction from October of 2022 out of Douglasville. He appeared to be on misdemeanor probation for that case. It was 11 months and 26 days probation. And he has 1 FTA from 2022, which is also the last arrest. And nothing further.
All right. ASG Gardner.
Thank you, Your Honor. This offense occurred about 4:30 p.m. yesterday at the Georgia State University Student Recreation Center on 101 Piedmont Avenue. The facts of the case are that the defendant entered the Georgia State University Student Center after being escorted from the property just the day before on January 26th and being told not to return. He was escorted off the property by staff member Mystery Maxwell at that time. And then on this occasion, he entered again by tailgating through the entry gate without paying to enter. When police were called, officers Adams and Pinozzo attempted to apprehend him. He fled on foot from them, refused to obey their lawful commands. After fleeing from the student center, he encountered officers Adam Peters and Keys also attempting to stop them. He continued to flee on foot and refused to obey their lawful commands. When officers Peters and Keys finally did catch him, he pushed past them, backing them into a wall and causing them all to fall on the floor. We are, concerned, of course, that he does have a previous conviction for criminal trespass, and he actually has a conviction for the FTA. The conviction was in October of just last year, and he is on probation. The bond is currently set at $1,500 per count. We would ask that it remain as that $1,500 surety bond per each of the 4 counts. Stay away from Georgia State University property, all of Georgia State University property, and no drugs, alcohol, or weapons. Nothing further from the state.
All right, PD Bartels.
Yes, thank you, Your Honor. I have spoken with Mr. Collier about this case. He does dispute that he was given a previous trespass warning. I am advised by him that he's actually registered at Georgia State, but he understands he can't go back to this location now, but he was not aware, he says, of any previous trespass warnings. He does have family in the area. His mother and father and brother, I'm told, all live in the metro Atlanta area. And I'm also told that he just started a landscaping job that's full-time. So given all that, he is wanting to ask for a signature bond. If the court is not inclined to grant a signature bond, we would ask for a $2,500 total bond. That would be, I'd say, $1,000 on the trespass and $500 on each of the remaining charges.
All right. And you stated that he is a registered student at Georgia State?
That's what I'm advised, Your Honor. I have not had an opportunity to verify that.
Is Mr. Collier trying to answer that question only?
Yes, ma'am. I'm not a student, but I registered. I started registration, but I never finished it.
Oh, okay. So you're not registered and you're not a student, correct?
Yes, ma'am.
Okay.
All right, yeah, thanks. Thanks for clarifying that.
And how old is Mr. Collier?
He's 20 years old, Your Honor.
I'm going to order a surety bond. The first charge being 1,000, 500 on the other 3 charges. So is that 2,500?
Yes, Your Honor.
Okay, just doing quick math. So there'll be 2,500 total surety bond. I'm going to order no drugs, alcohol, or weapons. I'm going to order stay away from the Georgia State University Student Center. I was going to say the whole campus, but I think it now takes up all of downtown Atlanta. So that would be a pretty vast.
That would be very difficult, Judge.
Very difficult.
I don't think I could do my job if I had to do that.
I tell you, they keep taking over more buildings. But Mr. Collier, please limit yourself on buildings for that campus, but certainly do not go back to the student center on Piedmont Avenue. And I'm almost going to tell you, be careful about any other buildings because you'll probably be on the radar for trespass if you go to any of the other buildings. I'm also going to order no drugs, alcohol, or weapons while on bond. And there was no request for no victim contact. I heard a name, Miss Maxwell, but did you ask ASG Gardner for a no further contact or anything?
I did not, Your Honor. I think as long as he stays away from the student center, that would suffice, except for possibly out of an abundance of caution, just because she is named in the warrant. Possibly we should have a no contact with her. He wouldn't have any other reason to contact her, to my knowledge. And her
Right.
name is spelled Mysterri, Maxwell, Maxwell.
Okay, so we'll order no further contact with Miss Maxwell. Anything else, counsel?
Nothing, Your Honor. Thank you.
Nothing
All
from the
right,
state,
thank
Your
you.
Honor.
Okay.
Position 3, Mr. Daughtry.
This is 23 CR 0000548G, Michael Daughtry, charged at 1 count of simple battery. I'm sorry, 2 counts of simple battery. Third charge, willful obstruction of a law enforcement officer, and the 4th charge of SB. Offense date January 26, 2023. Pre-trial.
Showing 7 cycles. I'm showing his last arrest being from February of 2020 for possession of marijuana less than an ounce. There's no disposition listed on that case. He does appear to have a 2017 willful obstruction of a law enforcement officer conviction out of Fulton County. And nothing further. He had 1 other sample battery family violence arrest in 2014, but that case was dismissed. And then another battery from 2011 also dismissed. Nothing further.
All right. ASG Gardner.
Thank you, Your Honor. This incident occurred at the Mobile gas station at 121 Cleveland Avenue Southwest in Atlanta. On January 26th, late in the evening, after 11:30 p.m., the defendant entered the property, by all accounts, obviously intoxicated. As he entered the store, he grabbed Miss Valerie Williams' hand and squeezed it in an aggressive manner. Now, Miss Williams did not know the defendant and immediately pulled her hand away from him. And then he went on into the store. He stayed there for several minutes and then he left again. While Mr. Wayne Wright and Miss Rachel Colbert were going inside the store. As he passed them, he reached out and grabbed Miss Colbert's groin area with his hand and without her consent. Mr. Wright, who is Miss Colbert's boyfriend, confronted him about what he had done. In response, the defendant punched Mr. Wright's chest, making him fall to the ground. A store employee, Mr. Travis Hill, escorted the defendant off the property and contacted the police. When Officer McCure located him across the street, approximately 5 minutes later, the defendant, he stated in the warrant, was obviously heavily intoxicated. When Officer McCure attempted to arrest him, the defendant tensed up his body in an effort to avoid arrest and refused to obey verbal commands to put his hands behind his back so that he could be handcuffed. Officer McCure was forced to take him to the ground in order to effect arrest. Given his history and the violent offenses in his history, the state is asking for a $1,500 surety bond on each of the first 3 counts, and on the 4th count of SB, a $3,000 surety bond. Stay away from the Mobile gas station, to have no contact with any of the witnesses, which are Valerie Williams, Valerie Williams, Wayne Wright, and Wright is Wright, and Rachel Rachel Colbert Colvert, or any of the store employees, including Travis Hill, who escorted him off the property. No drugs, alcohol, or weapons. Nothing further from the state.
Good afternoon, Your Honor. My client is 33 years old. I did not hear of any violent convictions in his history, Your Honor. He tells me that he doesn't have any recollection of any of these events. He does not have any memory of grabbing anybody or being in any kind of confrontation, Your Honor. I do not think that my client has any significant criminal history, just based on what pretrial has said. He is gainfully employed. He is from the Atlanta area. He doesn't have any history of FTAs or probation violations or any such thing. And also, this was an incident involving strangers, not family members or any such thing. So there's no difficulty with him staying away from any of the individuals named. I would ask the court to give my client a signature bond so he can get out of jail and get back to work. He tells me that he is employed as an Amazon driver, and I'm sure he will turn up for court to answer to these charges, Your Honor. Nothing further.
And Your Honor, if I may, I do not have convictions for battery on my list. I'm having a very hard time hearing pretrial. I thought she said there were 2 battery convictions on her list, but I may have misunderstood that.
No, she said there were dismissals. That's what I heard.
Yeah, pre-trial.
Leaning forward.
Pre-trial.
Dismissed.
Were we correct? Did we hear that correct about his history? For
Dis-
position 3?
Yes, dismissed.
Okay. That there are no convictions and no FTAs, is that correct?
I'm gonna take these headphones out.
Okay.
The 2 battery cases I said, they both were dismissed. He did have 1 conviction, I believe, for willful obstruction from 2017. And no FTAs, that's correct.
Okay. All right. And again, these victims are I'm assuming the employees of the mobile gas station.
One
No,
is an employee, Your Honor, and 2, and I believe the others were just customers based on what the
Customers.
warrant said.
Yes, Your Honor. Only Travis Hill was an employee of. All 3 of the rest of the victims were, or all 3 of the victims were actual patrons of the store themselves.
Okay. All right, I'm going to order a surety bond. And let me add this on the 2 simple battery charges. That will be $1,500 each. On the willful obstruction, that will be $1,000. And then on the 4th charge of SB, there will be a $2,500 bond. So what does that total, Ms. Lewis? Let's see if we get the same thing.
6,500.
6,500, yes. $6,500 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. Gonna order stay away from the mobile gas station, 121 Cleveland Avenue Southwest. And I'm going to order no further contact with, is it 3 victims or 4 victims?
3 victims and any store employee is what we were asking for, Your Honor.
All right, the 3 victims and any store employees. Mr. Daughtry needs to stay away from that mobile gas station or else you'll be back in jail. Anything else, counsel?
Nothing from the state. Thank you, Your Honor.
Mm-hmm.
Nothing further, Your Honor.
Okay.
Position 4, Mr. Dawson.
This is case number 23 CR 0000549F. James, and I believe it's Dawson, or Dawson. Charge of 1 count of battery in a public transit vehicle or station. The offense date is January 27, 2023. Pre-trial.
I'm showing 34 cycles total. Last arrest was October of 2022 for battery. He appears to be on probation out of Fulton County for robbery. 18 SC 158963. The disposition was September of 2019. It was 2 years confinement, 18 years probation. Has a disorderly conduct conviction from 2017. Theft by shoplifting conviction from 2017. Probation violation from 2018. Along with that robbery conviction was also a battery in public transit and a simple battery. A second probation violation from 2022 and one FTA from 2022. A simple battery conviction from October of 2022. And then he has arrest out of Colorado with a harassment conviction from 2010. Assault, aggravated assault, or there's a felony assault conviction also from 2011. A parole violation from 2015. A weapons offense conviction from 2021. A felony assault conviction from 2021. And further.
Honor, if I could ask, this was that case that I was asking about.
Oh, this is position. This is position 4, or was it 5?
I'm sorry, I may have gotten those two mixed up, but it
Oh, I
was
see the
position.
name. Okay, I do see the name. Sorry about that. So we
Sorry, I
still
did
need,
confuse the number.
yeah, we need to go into breakout. So you still want to go into breakout, Mr.
Yes, Your
Barker?
Honor, if we could.
Okay.
Judge, when there's some other cases that need to go on a breakout, can y'all do all at one to talk about?
Oh, that's right.
Or-
We have the other one, position
cases.
13 as well. Yes, deputies, can we save this one? What is it, 5 and 13 for the last two? I can hear the facts if you want, and then go to the other one and then rule on them, or just how we do it to make it efficient. Do you all want me to hear the facts now, and then we hold on a ruling and then go to the other position so that we can go into a breakout together?
I wouldn't have any objection if
Okay.
Okay.
they can state what the allegations are.
Your
I would
Honor, I
just-
still have another case, which is not a breakout room case.
Oh,
Mr.
you do?
Kicklighter.
What number is that one?
I'm not sure, Mr. Kicklighter?
Devin is the other conflict.
Oh, there must be 7.
Yes.
And I think, let's see. We have 7 and 8. Deputies, can I change your order a little bit and do 7 and 8? And then we do the 2 breakout ones last?
Yes, ma'am.
Okay, thank you.
We didn't do position 5. Can we go to 5 first?
Could proceed with that.
Oh, is 5 one of the ones you want to do in the breakout?
I'm sorry, Your Honor. Yeah, 4 was the one I wanted to do.
Excuse
I'm
me.
ready to
Oh,
go
so we
ahead
can
with
do,
5,
I'm
right?
sorry, we can do 5. Yes, Deputy, we'll do 5.
Excuse me.
Mr. Dawson, we'll get to you in a minute.
Okay, let's do 5. And that's Dominique Gay.
Right.
Okay. This is 23 CR 0000550C, Dominique Gay, charged with 1 count of criminal trespass, offense date January 27th, 2023. Pre-trial.
He has 2 prior arrests. The last arrest was a burglary from February 8th, 2022. That's an open case out of Fulton County, 22 CP 206-488. The first arrest was from Clayton County from February of 2021 for criminal trespass. No disposition listed.
Okay. All right. ASG Gardner.
Thank you, Your Honor. This occurred at the Valero Food Mart at 1980 DeLoe Drive Southwest. The allegations are that defendant was found at this Valero gas station, and when Officer Garces, I believe is how you pronounce the name, came to the gas station and talked to him, he said that he had gone there for a cigarette and to pump gas for someone. However, Officer Garces did note that he had told this defendant earlier that same day that he was to not return to the Valero because he had been issued a CT warning on September 11th of 2021. He was arrested without incident. The state does have some concern about the fact that he has such a recent burglary arrest in a case that is still pending. We're recommending a $1,000 surety bond, stay away from the Valero Food Mart, no contact with any employee there, and no alcohol, drugs, or weapons. Nothing further from the state.
Okay. And PD Bartels.
I have spoken with Mr. Gay. He does dispute. He said he was not aware that he was issued a criminal trespass warning. It looks like that was over a year. I don't know if warnings like this are time limited but he advises me that he was not aware of that. His history, as everybody has said, is fairly good. Does have family in the Atlanta area.
Mr. Bartels, you're going in and out on me.
Okay, can y'all hear me better?
Yeah, I was getting every other word, I think.
Okay, thank you. As I was saying, Your Honor, he said that he was not aware of being issued a criminal trespass warning. The date for that was over a year ago, almost a year and a half ago. So again, he advises me he was not aware of that. He does have family in the metro Atlanta area. I'm advised that his father and mother, his 3 sisters, as well as his aunts and uncles and some cousins live in the metro Atlanta area. So he does have ties to the community. I'm advised that he lives with his father, and he also works for his father doing house cleaning. So he is employed. And given all of that, and given the nature of this charge, the fact that he's already will have been in jail for a couple of days, we would ask the court to consider a signature bond. And if that's not the court's decision, we would ask for a $500 surety bond.
All right. I'm going to order a surety bond in the amount of $1,000. Going to order a stay away from the Valero Food Mart, 1980 DeLoe Drive. No further contact with any employees of that Valero Food Mart. And no drugs, alcohol, or weapons while on bond. It's a $1,000 surety bond.
Okay.
Thank you, Your Honor.
Okay. Yeah. Thank you, Your Honor. Nothing further on that one.
Okay.
We can go to position 7.
Okay.
Thanks to Matt.
This is 23 CR 0000553G. Justin, is it Kicklighter? Charge of 1 count of simple battery. Offense date January 27, 2023. Pretrial.
First arrest.
Okay. ASG Harmon.
Yes, Judge, this was an incident that occurred yesterday. This was around Old Dogwood Road in front of 1105 Holcomb Bridge Road in Roswell, Georgia. Judge, he was in a fight. Officers were called to that scene because he was in a fist fight with his brother, Sebastian Kicklighter. He did admit to the officers that he instigated and started the fight. Essentially, his brother was carrying a bag of groceries and he kicked the bag of groceries to the ground while the groceries were in his hand and a fight started. I do know that he did sustain some injuries, the defendant that is, as a result of this fight. Judge, we do think that he is a danger to the victim. We do know that they're siblings and siblings do fight, Judge, but this is extreme. And this shouldn't have occurred in the middle of the street with them fighting in the street and officers having to be called out. That goes beyond sibling robbery. In light of that, Judge, our recommendation in this case is a $2,000 surety bond to have no further violent contact with the victim, Sebastian, common spelling, Kicklighter. No alcohol, drugs, or weapons, the 1-day anger awareness class as well. Nothing further from the state.
All right.
My client is
McLeod.
My client is 25 years old, Your Honor. As Pretrial said, he's not ever been in any trouble and he has no arrest record. He tells me that he's currently unemployed and residentially challenged. He also tells me that he and his brother get along very well for the most part. And I am glad that the prosecution is not asking for no further contact because he does want to have contact with his brother, Your Honor. He is not in a position to pay for a bond, so I would ask the court to give him a signature bond so that he can be out of jail because he cannot post any other kind of bond. Nothing further, Your Honor.
All right. I'm going to order that $2,000 signature bond. I'm going to order that through the jail. I'm going to order no further violent contact with Sebastian Kicklighter. And I'm going to order no drugs, alcohol, or weapons while on bond. And so, Mr. Kicklighter, I'm giving you that signature bond so that you can go home and there will be no further incident.
Thank you, Your Honor.
All right.
Position 8, Mr. Lewis.
He'll be excused.
Yes, thank you, Ms. McLeod. Have a good weekend.
You too, Judge.
I'm sorry, Judge. I didn't mean.
Oh, that's okay.
Position 8, Mr. Lewis.
All right. This is 23 CR 000552G, Dwight Lewis, charged with 1 count of terroristic threats and acts and a 2nd count of simple assault family violence. The offense date is January 27th, 2023. Pre-trial.
4 cycles. I am showing the last arrest being from 2010 for trafficking in cocaine, illegal drugs, marijuana, or meth. Purchase, possession, manufacture, distribution, or sale of marijuana. That was a first offender. It was sealed September of 2019. And no conviction. No FTAs, nothing further.
Okay. ASG Harmon.
Yes, Judge. Judge, this case occurred at the incidental location of 2303 Swallow Circle Southeast in Atlanta. Judge, The defendant's son was at his grandmother's house, and that his grandmother's name is Paula Pierce. The defendant came to his mother's house, which is the victim's grandmother's house, banging on the door, demanding to be let in and demanding to see his son. He was screaming for the victim to come out, his younger son to come out. That son fled to the home of another person, trying to get away from his dad, seeing if somebody else would let him in for safety. And when that child was talking to police officers, the defendant called him while police officers were standing by. He put his phone on speakerphone. And while he was on speaker, the defendant stated to his son, "Now I'm going to kill your mama if you don't tell me where you are at." He went on to say, "I'm going to shoot your mama in the face." And that threat was witnessed, as I said, Judge, by police officers. And he did so for the purpose of intimidating the victim in this case. In his possession, Judge, when they did arrest the defendant that day, he had a 10mm Glock pistol on his person. Judge, we did already refer this case to the DA's office. We didn't make the cutoff, Judge, for a felony first appearance in this case. So we did accuse it here. And that's why it's before you on bond. We do believe that he is an extreme danger to the victim in this case. He had a gun in his possession when he was arrested. He clearly threatened to shoot and kill the victim's mom to be in contact with the child victim in this case, who is 13 years old. And Judge, we did speak to LaQuasha Lewis, who is the mother of the younger victim in this case. And she said that she's okay with the parties having contact, that's the defendant and the child, but the state is absolutely not. It is a concerning situation that he had a gun on his person and that he was banging on the door, demanding to see the child victim in this case. And Judge, it's concerning to the state that he would threaten that child with violence against his own mother. As I stated, Judge, this has been accepted by the DA's office. In his criminal history, Judge, I did locate some charges with no disposition. It was a 2005 simple battery, no disposition, and a 2010 battery, which was on the dead docket. Those are violent offenses in the defendant's past that further raises concern for the state. Our recommendation in this case, Judge, given those facts, are a $1,000 cash bond on the terroristic threats. And on a simple assault, we would be requesting a $1,000 cash bond as well. He has to have no further contact with the victims in this case. The mother of the child is LaQuasha Lewis, and I'm going to have to spell that. It's LaQuasha, last name Lewis. His mother, because he came slamming on the door, demanding to be let into her house, Paula Price is her name, and the initials of the child are DL. That's his son. We would ask that he would have no alcohol, drugs, or weapons, that he would be ordered to stay away from the incident location of 2303 Swallow Circle Southeast. And that's it, Judge. Nothing further from the state.
And Your Honor, good afternoon. Respectfully, Michelle McCutcheon for the state. Judge, because as Your Honor knows, because Your Honor has represented me in an unrelated civil matter, I do not argue most matters before the court. I did submit an order, even though Ms. Harmon is arguing this issue. I submitted an order. Would the court prefer that I have Ms. Harmon have her input her name as the submitting party?
I don't have a problem with it unless you do.
No, I do not. I just wanted to, is Ms. Braunstein the defense attorney? Yes.
Okay. I think, Ms. Lewis, you sent that to me, did you not?
Yes, ma'am, I did.
All right,
Okay.
thank you, Judge.
I will be signing that. Yes, thank you.
Thank you, Your Honor.
And I have someone.
One second,
Yeah.
1 second, madam. And Judge, I just want to put on the record, we did make, like I said, we did make contact with the
I believe she's
child
on
victim's
Zoom right
mom, and I
now.
think she's on the Zoom now. I just didn't want her to just pop in the chat and you didn't know what was going on, Your Honor.
Right, thank you. All right, yes, ma'am, you are showing up as iPhone. Normally, we would like to have your name, but I will, in the essence of time, ask you what your name is.
It's LaQuosha Lewis, and it's spelled Laquosha.
All right.
And I just want to say that
Hold
they
on a
didn't find
second. Hold on a second. I haven't given you permission to speak yet, and I need to swear you in if you're going to address the court. And what is your relationship to the defendant?
I'm his wife.
You're his wife?
Yes,
And were you on the scene of this incident?
I wasn't there because
You
we're
were not-
currently not together.
I'm sorry?
We don't live together right now, so I wasn't there.
Okay, well, I do not know. This is just a bond hearing, so I'm not sure what you're going to add, since you were not there on the scene that would,
Hold on, my phone just volume just.
since you are the wife of the defendant, Mr. Dwight Lewis, is that correct? And you were not on the scene to add any information. I'm very limited with having you to speak or address to the court today. This is just a bond hearing.
Your Honor, if we could hold that until after I speak, I can explain why her input could potentially be necessary. I do have an argument to make.
Okay, let me, Ms. Lewis, let me hear from PD Bronstein first. And then if I need to hear from you, I will give you permission to speak, okay? All right, go ahead, PD Bronstein.
So, Your Honor, the reason that I thought that it would be important for the court to hear from her is that Mr. Lewis is charged with terroristic threats of shooting her in the face, killing her, and those words were allegedly communicated to the 13-year-old son. However, there would need to be an expectation that that threat would have been communicated to her, and she was not there, had not heard about it until the victim's advocate called. So I would argue that there is no probable cause even for this, because there was no expectation that that threat would have been communicated to her. And I felt that it was important to know whether she would want contact, be comfortable having contact, because she would actually need to be the victim of the case, because the threat was made about her, despite her never hearing of it and there being no expectation that she would. So that is my argument as to why her input is important. I do have arguments about bond and about the other charge as well, but if the court just wants to go from there, then I can fill in the rest after.
All right, ASG McCutcheon, do you want to address that first before?
Yes, Your Honor. And
Bronstein goes to, yeah,
yes.
go ahead.
Ms. Bronstein, just so you're aware, you heard my earlier announcement. Do you have any issue with me representing the state and presenting this argument to Judge Mincy?
So I was having issues hearing.
Okay, Judge Mincy has represented me in a civil matter regarding a property dispute totally unrelated to this case or any cases in Fulton County. It did not even occur in Fulton County. But under the advisement of the bar, I always let the parties know, so that if you believe there's any conflict, then of course another prosecuting attorney from our office would make the argument to the court.
No, that's fine.
Okay,
right,
Judge, and I'll
thank you.
state my place, Judge. The reason that this case was delayed in getting a response, because I quite frankly was not certain whether or not the case would arise to a felony terroristic threats. I did send the case over to the deputy ADA who reviews these cases. The clerk of magistrate court has informed us we need to get these cases to them if we want to upgrade them to felonies by 9 o'clock in the morning. Of course, when I sent it to the deputy Turner in the DA's office when I received the response back from him, because of course it is Saturday and he does not normally work, but he will answer our emails. It was about 10:30 in the morning. So I advised my team members to go ahead and accuse the case as a misdemeanor so that the defendant could come before the court on this afternoon, since the felony first appearance, as you know, would already have possibly recessed. But the state's position is that the DA has decided that they will accept the case. That's why I submitted the order to the court. The deputy ADA personally emailed me back and said to send the case over. And we also added a simple assault charge to the case. So of course, any arguments the defense counsel would make regarding the probable cause of the case, we've already accused the case. The case has been filed in state court. Any arguments counsel regarding probable cause for the felony terroristic threats now would go before the Superior Court, and the district attorney's office would handle that since they have accepted the case for felony prosecution.
And I just wanted the court to be aware of why Ms. Lewis was important, and that would pertain to my bond arguments.
Okay.
Okay. Well, I did hear P.D. Bronstein in the presentation, and of course, with ASG Harmon, that the terroristic threat was relayed to the 13-year-old son, the minor, and then the officer was listening because it was on speakerphone. So
correct. There would need to be an expectation that that threat would have been relayed to Ms. Lewis.
All right, I'll allow Ms. Lewis to testify about that, very limited, and whether she wants contact or anything like that. I'll let her testify briefly because she's here, but that would not change my opinion as far as the case going forward. It's now I'm going to sign the transfer order. So I agree with ASG McCutcheon that it would have to be argued at the preliminary hearing in the Superior Court, because the case is going to be ordered to be transferred. So Ms. Lewis.
The only thing that I want to add,
Miss Lewis, hold on a second and listen to me. Raise your right hand for me if you're going to address the court. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Are you in a place where you cannot be overheard by others?
Yes.
Okay. All right. Go ahead and briefly tell me what you'd like to tell me.
I just want to clear up that he didn't have a gun in his possession because he had a clip in his pocket, but he didn't have the gun because I have the gun. So yeah, that's not true. I have the gun in my possession. He don't have my gun. He had the clip in his pocket. That was it.
Okay. All right. Are you in fear of Mr. Lewis?
I am not.
Okay. All right. And so we also want to make sure the 13-year-old, what are his initials?
DL.
C as in Charlie.
D as in David.
Oh, D. I'm sorry. DL.
Yes.
Okay.
Yes.
All right. So we want to make sure that DL is going to be safe as well as you. When people give terroristic threats. I'm sorry?
I said he probably can't be put on camera because I already spoke to him. He doesn't care as long as he doesn't come near him. So, I mean.
Well, we're going to make sure of that. In any bond conditions, there's usually no further contact with the victims, whether they're adults or minors. So I would certainly order that in any bond that I consider today. There will be no further contact with you and your son, DL. So there will be no further contact with the two of you. I'm sure about that. And so I just wanted you to know that. And without giving any other advice, we want to make sure that you and your son are safe from any perceived threats or actual threats. Because the information that you gave doesn't necessarily make me feel any better. But I want to make sure that you and your son are safe, okay?
Yeah.
Okay. All right. You can mute yourself. Thank you. Anything else, counsel, before I give my ruling?
Yes, Your Honor, I have not actually made my argument.
I'm sorry, Ms. Bronstein. That's right. We were talking about that. Yes, go ahead and present. I'm sorry.
Thank you. Mr. Lewis is 30 years old. He is from Atlanta. His whole family is here, his parents, siblings, his grandmother. As Ms. Lewis stated, they're currently not staying together right now. His last arrest was well over a decade ago and has no convictions or FTAs on his record, so he certainly would not be a flight risk. And let's see. Oh, yes. And he is working. He works at ResMed and has for over 2 years now as an auditor working on the CPAP machines. So he is requesting based on the length of time since a last charge, his ties to the community, no FTAs. He is requesting that the court consider a signature bond, if not, that a bond not be greater than 1,500 surety.
And Judge, before you make your ruling, I do want to correct. I went back and reviewed the police report. Ms. Lewis is correct. He was arrested with a 10mm Glock pistol magazine. He was arrested with the magazine, but that doesn't alleviate any of the state's concern. And I heard her say when she was speaking to you, Judge, that DL didn't want any contact with the defendant. So we would ask that you would, we still think that the magazine was suggestive enough and that it's still an extreme danger to both of these victims, all three of these victims in this case. And so we're still asking for cash bonds in this case, Judge.
All right, thank you.
Mr. Lewis, please don't speak at this time. Thank you.
All right, I do understand it is concerning to me. And we have a 13-year-old that certainly needs protection from the court. And I'm very concerned about that and hope that everyone will first think of the safety of this young child. I'm going to order the $2,000 cash bond, $1,000 on each charge. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order that there be no further contact with the victim, DL, a minor son. I'm going to order no further contact with LaQuosha Lewis. I'm going to order a stay away from 2303 Swallow Circle Southeast. And I think that is it for now. Anything else, counsel?
Just that she would have to be the victim. Again, based on the statute, based on the case law, I did a lot of research on this morning. I do not believe that there is probable cause for that charge as it is charged and as the law is written. And I am asking that there not be a cash bond.
All right, so noted. Your client still has his hand up and I think he's trying to talk. So I guess you can instruct him.
Mr. Lewis, if it's about this case and the facts of this case, I do not recommend speak. Okay, what?
I have to be to work Monday. I can't afford a cash bond. I just got back. My grandmother is terminally ill. She just had cancer surgery. She's in hospice, in-home hospice. I'm her caretaker. I just went back to work last week, my first week. I can't afford a cash bond, a $2,000 bond at that. I can't afford it. And I'm not saying I'm a saint or I didn't do anything wrong.
Oh, wait, Mr. Lewis, don't talk about the actual charge.
I can't afford that bond. I just want to go to work. I stay away from everyone. I just need to go to work so I can afford to take care of the case. I won't have to jeopardize losing my job for almost 3 years. I just got a good job with benefits. It took me 2 years to get this job. It's a great job. I understand it's allegations, but I can't make the $2,000 cash bond. And my grandmother is terminally ill. She's at 9596 Old Archery Court, and I'm her primary caregiver.
That I hear you, Mr. Lewis, but that is the ruling of the court. This is a very serious case and serious allegations. So we want to make sure that the parties, the victims will be safe. So I'm going to stand on the ruling of the court. Thank you. And who do we have, Deputy?
The two breakout.
Okay. All right, Ms. Lewis will go into breakout. Looks like we're gonna have PD Bronstein, ASG Harmon, and ASG McCutcheon. Mr. Bartels, are you going in with us? Yes.
Yes, Your Honor, that's on case number 4.
Oh, and is Ms. Bronstein going in?
For position 13, Mr. Smith.
And then Ms. Garner. I guess all of us who are left. How about that?
Do you need, to do the,
That's good.
do you need
That's
to hear
good.
the, do you need to
I'm
hear,
sorry, Ms. Lewis.
do you need pretrial? You want to hear the history for pretrial before I put you in
Oh, I
the
didn't
breakout
hear,
room?
I didn't hear the history. Yes, I'm sorry. Pretrial. Let me have the history first before we go into the breakout. And that's on position 5. Let's see. I have the history on position 5. And then I don't have the history for the other case, which was 12. Is that correct? I'm sorry, 13. Randy Smith, 23 CR 0005556G, charge of 1 count of criminal trespass. That offense date is July the 10th, 2022. Pretrial.
Judge, are we on 13 now, or we are on?
Yes, 13. Yes.
I'm showing 5 cycles. Last arrest was June 26th of 2022 out of Fulton County for criminal trespass, 22 CR 004095G. That does appear to be an open case, and that appears to be a pretrial bond, so we're going to surrender that bond. He appears to be on probation out of Fulton County for criminal trespass, disorderly conduct, and obstruction, 22 CR 00888A. Disposition was June 7, 2022, 12 months confinement, credit for 15 days, and balance was to be prorated. And nothing further.
All right, thank you. All right, now we're ready to go into the breakout.
Your Honor, you're on mute.
Oops, sorry about that. I said, well, they're gone. Maybe that wasn't the last person sitting in the courtroom. Oh, deputy. Deputy.
Yes, ma'am.
I thought there wasn't the last person sitting in the courtroom. That wasn't Mr. Dolson.
Yes.
Okay, because I don't think there was not a waiver for him. I was just going to explain a
No,
$2,000 cash bond, but I understand why you might have moved along.
we just put him in the back because, you know. he got-
Okay, right.
Yeah.
Okay.
Okay.
That's fine.
All right.
Obviously, that was a reason.
So it was a behavior.
Yes.
Okay, all right, I can execute a waiver and just.
Okay,
Send it.
let's
I've
do
already
that.
sent the,
Was
I've
he
sent
going
the
again?
order and the referral form, but I'll send a waiver
Bring
to
them
you.
back out.
I'm sorry,
Miss.
say that again, Miss Lewis.
He's bringing them back out.
Oh, they're
Oh.
bringing it back out.
Put
Okay,
them in the back.
Oh, I
All right.
see it.
Back temporary.
understood.
So he's bringing them now.
Okay.
Newspaper, cup of coffee, bro.
Mhm.
Not the body man.
Is it Mr. Dolson?
Mr. Dawson, yes, ma'am. How you doing,
I'm fine. Wanted to just let you know, we discussed your case in a breakout, but I wanted to let you know what your bond is. Your bond is a $2,000 cash bond. You'd have no drugs, alcohol, or weapons if you get out and make bond. And you are to stay away from all MARTA until this case is over. And you'd have no further contact with Shaika Speller, who is the victim in this case. And then we're going to order some evaluations. So I just wanted to let you know that, okay?
kind of evaluations?
They're going to be MH evaluations.
Yes, you magistrate?
I'm sorry?
Yes, you magistrate. What type of evaluations? Yeah.
Yes, evaluations. So those will be done. And I just wanted to let you know what the ruling was on your case, okay? I think he's muted for a reason. So,
Dawson, can you hear us?
Yes, sir. I mean, I've talked to you very clearly, sir.
okay. Once you start talking, it goes back to mute, so we can't hear you. Okay, go ahead again.
Okay.
What were you saying, Mr. Dolson?
But I was saying, ma'am, I'm not a joke, ma'am. I know you guys at the courts respectfully aren't any joke either. Respectfully, I'm getting evaluation to determine my legal status as far as being charged with what I'm charged with. I'm in charge with my lawyer, my first defender, court-appointed lawyer, told me Bartell, told me Paul Bartell, Mr. Bartell told me I was being charged with assault. I don't need any evaluation now. I really don't. I mean, $2,000 bond for what I'm in charge with, ma'am, is really active. That's active to me.
Well, sir, I didn't advise you assault. You're charged with battery.
Okay, well, sorry, so I'm not a sex offender. What I'm saying, I heard all the cases, you know, when since I've been sitting here within the last hour. Ma'am, you magistrate Missy, I do not need an evaluation. I mean, you know, I don't know what's going on with this young man here that's laughing. He's probably about the same age. I'm 51 years old. He's probably a little older than me. I don't know what the case may be with him laughing, but I'm very serious about what I do for a living. What I do for a living is work for 5 guys. I stalk. I might have a couple of items that people might buy and I get a percentage off of. I mean, I'm not 5 guys, but five below. It's called it's hold on, brother. Hold on. It's called a national where you see where you, I don't want to put their business out there because I'm in jail right now, but he did call, my lawyer did call them. it's a business where you get deals from buying two packs of stock, you get a sparring deal. Basically.
But your lawyer is representing you well. And I'm going to sign that order for the evaluation. If you don't need any additional treatment or evaluations, it will note that. And then that will be the end of it. If it does note that you need some other assistance, then that will be provided to you. But I think on the side of caution, I'm going to order that, and then we'll see what the outcome is, okay? Okay,
Thank you, Judge.
all right, thank you. All right, we can reconcile in a minute. Thank you, Deputy. That will conclude that case. Yeah, that will conclude the case, Deputy.
Yes, ma'am. Hold on.
Courtroom. Oh, Deputy. Or turn his camera off.
Position 13, he's been waived.
Yes, and we talked about that one in the breakout, so that's a $2,500 surety bond on that one. So we did discuss that in the breakout, Deputy.
All right, thank you. So that should be it in the courtroom.
Right. That is it. Yes, thank you. Have a good
All right,
weekend.
thank you.
All right, you too. Okay.
Everybody ready to go over the counter?
Yes, ma'am.
Okay. Remember the SAP reset date is gonna be February the 9th. Position number 1 is a total of a $5,000 SOB through pretrial per judge. Position number 2 is a total bond of $2,500, good bond. Case is set for SAP. Position number 3 is you set for SAP. Total bond is $6,500 surety bond. Position number 4 is going to be set to the next competency counter, February the 16th, a $2,000 cash bond. Position number 5 is going to be set for the SAP, a $1,000 good bond. Position number 6 is reset for the notice. The case has a $5,000 SOB through pretrial per the judge. Position number 7 is going to be set further notice. It has a $2,000 SOB through the jail. Position number 8 is going to be set for the SAP counter. It has a total of a $2,000 cash bond. Position number 9 is going to be reset for the SAP counter. It has a total of a $2,500 surety bond. Position number 10 is going to be set further notice. It has a $5,000 SOB through pretrial per the judge. Position number 11 is going to be set further notice. It has a total of a $5,000 SOB through pretrial. Position number 12 is going to be set to the SAP counter. There is a total of a split bond of $10,500, $10,000 on the first charge, $500 cash bond on the second charge, and also there is a transfer. No, not transfer. That's the wrong one. Okay, I know what I'm talking about now. Sorry, Dom. No, yeah, I'm just getting them mixed up here.
It's okay.
But no, that's a $10,000 split bond, $2,500 split bond. I'm sorry. Position number 13 is a reset for a competency counter. It was a $2,000 $500 surety bond. Position number 14 to be set for SAP. That was a $2,000 surety bond. And I'm sorry, the position number 8 has a transfer order.
All right.
And that completes the calendar.
All right.
Concerns?
Yes, anything else?
Nothing further from me.
All right, everyone, enjoy the rest of your weekend.
And I got the order, Mr. Bartell.
Okay, great. Thank you.
And Judge, I'll be sending those over to you immediately.
Yes, ma'am. Thank you. Everybody
Thank you,
enjoy your
Judge.
weekend.
All right.
Good
All right.